Well, good morning and welcome to our next panel in the 2022 World Arbitration Update. It is the 9th or 28th of September 2022, and we have the privilege of presenting to you a panel that I think will be of particular interest to everyone in the arbitration field. Before there was investor state arbitration, there was the Iran-U.S. Claims Tribunal. And today, the topic of our panel is influence of the Iran-U.S. Claims Tribunal on public international law and investment law. And we have a fantastic group of panelists to talk on that topic. And I'm personally very much looking forward to hearing their insights into that topic. Before that, a few administrative points. We just wanted to thank our sponsors. We've had a real upswell of support for World Arbitration Update, and we just need to recognize our sponsors for their incredible support and input into this year's conference. As folks know, this is a one week conference with 19 different panels on an array of topics related to international arbitration. One of the things that we're very proud of is the objectives of World Arbitration Update, which is very much focused on recognizing the diversity of international arbitration and the fact that international arbitration can be found basically in every corner of the world, and it has a huge variety of different cultures and legal traditions. Supporting it and providing input into it, and part of the desire of an objective of WOW is reflected in the fact that we have tried to cover off a range of topics in different regions of the world. We had some excellent panels yesterday on sub-Saharan Africa and MENA. This morning, the panel was in Singapore. It's just been a fantastic conference, and I just wanted to thank in that light my colleague. I guess I should have introduced myself. My name is Ian Laird. I'm partner here at Crowell & Moring in Washington, D.C. My co-chair and the real brains behind WOW is Dr. Jose Antonio Rivas, who's on the screen, and his great team at X Strategy LLP. Anna and Maria Lucia have just done a fantastic job herding all the cats and making the trains run on time, to mix a bunch of metaphors. So full commendation and kudos to them for their excellent work. So let me pass on to Jose Antonio, and we can start to kick off this morning's panel. Jose Antonio.
Thank you, Ian, and thank you for your kind words. This is, as you know, a team effort, and I very much enjoy our collaboration and partnership in this very ambitious project, which is the World Arbitration Update. As you mentioned, our objectives are: one, to update the international community on issues of public international law, investment treaty arbitration, and international commercial arbitration. And the other objective is decentralization. And I said it this morning in our previous panel on the Ukraine crisis created by the Russian invasion. When I looked at the screen and when I reflected on the legal traditions and faces and without any remorse, this is how diversity looks like. We're really proud of having a diverse set of panelists in many respects: legal traditions, cultural traditions, nationalities, etc. Here we are in the panel on the Iran-U.S. Claims Tribunal, and I was commenting with our panelists a few minutes ago how this topic came to fruition within the notion of bringing topics of public international law that interrelate to investor arbitration. The Iran Claims Tribunal and its jurisprudence is one that has strongly influenced investor arbitration and public international law. It seems to be like a lot of work being done in the tribunal, and sometimes not enough being publicized and updating the international community about the impact of that tribunal. In the U.S., we know much about it because it involves the U.S. But I think that it's in the wider world, it's important for everyone to know. So I've had many requests by many in various continents reaching out and saying, are you recording this because it's not in my time zone, etc. So rest assured that we will be posting this video and we will be launching a new app so that people can term search the actual recording. So with that, I would like to introduce Heather Clark, who is a legal advisor at the Iran-U.S. Claims Tribunal. Heather has together with us been sort of the brains, the real brains behind this panel. We have been exchanging jurisprudence, comments, articles to choose what I believe are the strongest and most competent panelists to talk about this case law and jurisprudence, both from the Iran Claims Tribunal itself, but also from investor arbitration and academics as well. So Heather has not only been at the Iran Claims Tribunal, she was also an attorney and associate at White & Case. She has been assistant legal counsel at the Permanent Court of Arbitration. She has also, by the way, worked in intellectual property matters as a consultant. And when I look at what she has done, it's quite impressive to know the breadth of her knowledge, and we're really lucky to have her here and to have partnered with her to put together this panel. So I won't embarrass you anymore. And by the way, she's also a scientist in the sense of physics. So we learn every little detail when we get closer to a panel at wow. All I can say is wow. Anyway, let's move forward. And Heather, you have the floor, and we're really happy to have you here.
Wonderful. Thank you, Jose Antonio, and thank you, Ian, for the warm welcome and for the opportunity to moderate the panel today. I'm actually going to start with a little bit of a description of the tribunal itself, because I know that some of our audience members will be familiar, but others may not. And then I'll go on to introduce our panelists, because that kind of provides the context for their respective experiences, and then I will explain how we'll proceed for today's session. So to start with the description, the tribunal was established in 1981, so that's more than 40 years ago, as part of a negotiated settlement to a severe crisis in relations between Iran and the United States. Previously, they had quite close economic, military, and geopolitical ties. And the immediate cause of the crisis was the detention of 52 American citizens in the United States' embassy in Tehran. And that was between November 1979 and January 1981, as well as the measures that were taken by the United States in response, which included the freezing of billions of dollars worth of Iranian assets. So the settlement of this crisis in relations was expressed in the form of two declarations. And these were declarations by the government of Algeria, who had acted as an intermediary in the negotiations. And the two states, Iran and the United States, agreed to be bound by these declarations. So first, we've got the general declaration, and that sets out the substantive obligations of the parties. And then what might be most interesting for us today is the Claims Settlement Declaration, which established the tribunal itself. And the tribunal is best described as a kind of standing international arbitral tribunal, because it looks a lot like a permanent body, but it really isn't one. It has actually quite limited jurisdiction in terms of the subject matter of the disputes, the time period concerned, and the parties. And most importantly, when it's completed all of its work, it will cease to exist. And the last point I wanted to make in this little brief introduction is that the work that we're doing today at the tribunal relates exclusively to disputes between the two states. And those relate either to the interpretation and performance of the Algiers declarations that I just described, or to contractual arrangements between the two states for the purchase and sale of goods and services. So I think that tells you a bit about the nature of the tribunal as well. And previously, and this is maybe most relevant to today's discussion, the tribunal dealt with a very large number of claims by private parties against one or the other government. And so this category, which formed the bulk of the tribunal's docket until the early 90s, will be the focus of the discussion today, because that concerns the influence of this body of jurisprudence on public international law and investment law. So now I will introduce our panelists. I'll begin, I'll describe them in the order that they will speak. So I will begin with Mr. Reza Eftekar, who is my friend and colleague at the tribunal. He will be addressing issues of jurisdiction. He holds a BA and a master's degree from Shahid Beheshti University in Tehran, as well as a PhD from Leiden University. He has acted as counsel in various commercial and investor state arbitrations, and has also been acting as a legal advisor. He was then acting as a legal advisor at the IUSCT at the tribunal since 2013. He recently published a book with Brill that addresses the role of the domestic law of the host state in determining the jurisdiction ratione materiae of investment treaty tribunals. So welcome, Reza. So next, we will hear from Damien Charlatan, who will be addressing you on issues of nationality. So Damien has studied at Sciences Po and Columbia and recently completed his PhD at Cambridge. He is, among other things, a lecturer at HEC in Paris, and also a senior analyst for a publication that I'm guessing many of us read on a daily basis, the Investment Arbitration Reporter. So one of the most interesting things about the tribunal is that, particularly in the early years, is that almost all of its output has been made public. So not just awards, but I mean, the awards form the bulk of the published material. And what Damien has done is he's performed this really fascinating quantitative analysis of the tribunal's output, which he's captured in an article which was published in the Journal of International Dispute Settlement, which I highly recommend reading. And this is called a data analysis of the Iran-U.S. Claims Tribunal's jurisprudence, lessons for international dispute settlement today. Welcome, Damien. Okay, next we have Aniruddha Rajput, who is a member of the International Law Commission and also a consultant for Withers LLP in London. He holds a PhD in international law from the National University of Singapore, and he began his studies at the ILS Law College in Pune in India. He has acted as counsel in many cases, including before the International Court of Justice, the Supreme Court of India. And he was also a member of the study group that was constituted by the Law Commission of India to address the 2015 model BIT prepared by India. He is also the author of a book entitled The Protection of Foreign Investment in India and Investment Treaty Arbitration, and that's been published with Kluwer. So he will be addressing you today on indirect expropriation, which was also the subject of a very thought-provoking piece that he published in the ICSID Review entitled Problems with the Jurisprudence of the Iran-U.S. Claims Tribunal on Indirect Expropriation. Welcome, Aniruddha. And last but certainly not least, we'll hear from Kabir Dugal. Kabir teaches on various aspects of international dispute settlement at Columbia and at Fordham. He holds not one, but two PhDs, one from an SJD from Harvard Law School and a PhD from Leiden University. And he began his academic trajectory at the Government Law College in Mumbai. I like to go back to the very beginning for everybody. Not high school, just university, don't worry. He is also a senior advisor with the International Arbitration Group at Arnold and Porter in New York and acts both as arbitrator and as counsel in various investor state and commercial cases. And Kabir will be rounding out our discussion today with a presentation on damages. So welcome, Kabir. And last but not least, we will, the plan for today is that each of the panelists will speak for approximately 10 minutes, but we will then take questions from you, the audience, via the chat. So you can put them just directly into the public chat. And I will carefully select the juiciest questions for the panelists. And then to close, I want to give each of our panelists an opportunity to spend a few minutes making kind of concluding observations on the discussion today, because everybody will be discussing quite discrete topics, but it'd be nice to kind of have a bigger picture at the end of today's discussion. And then we will make sure that at the end, we still have time for some sort of informal interactions in the breakout rooms. So I think that's it from me. So let's begin. Reza, you have the floor. Thank you.
Thank you so much, Heather, for the introduction. Let me pull up my slides. Okay. So, good day, everyone. This is Reza Iftekhar. It's a great honor to be able to address you on the occasion of World Arbitration Update 2022. I'm grateful to the very competent chairs of this webinar, Dr. Jose Antonio Rivas and Professor Ian Bird, and their wonderful colleagues for their very kind invitation. It's a true privilege to play a part in this admirable effort. And my task today is to open the panel discussion on the influence of the Iran-U.S. Claims Tribunal on public international law and investment law. More specifically, I'm going to talk about the jurisdiction of these two institutions, and through that prism, to see to what extent the practice of IUSCT may be relied upon in ISDS. And please bear with me as I use the shorthand form of IUSCT for Iran-U.S. Claims Tribunal and ISDS for Investor State Dispute Settlement. The poor legal advisor has only been given 12 minutes, so you would appreciate that I have to be more economical when referring to the titles of institutions. Before I embark upon my topic, as the first speaker on the panel, I have to say something about the theme of this webinar, World Arbitration Update. Now, the term update always gives professionals some level of anxiety. You keep asking yourself, to what extent I shall reacquaint myself with the latest developments of law? Well, luckily for this topic, I did not have to wait for long to find some very fresh references in ISDS to the work of IUSCT. In an award rendered on 6th of May 2022 in a case filed against the government of Spain, the Exit Tribunal, speaking in the context of the occurrence of an indirect expropriation, referred to one of the tribunal's high-profile cases. It said the following: in Starrett Housing versus Iran, the Iran-U.S. Claims Tribunal described an indirect expropriation in the following terms. It is recognized in international law that measures taken by a state can interfere with property rights to such an extent that these rights are rendered so useless that they must be deemed to have been expropriated, even though the state does not purport to have expropriated them, and the legal title to the property formally remains with the original owner. And then it continued, in that case, as well as in other cases decided by the Iran-U.S. Claims Tribunal, and here the Exit Tribunal is referring to Setco, ITT Industries, Tippett, Abbott, McCarthy, and Stratton. The text continues, the appointment of managers by the government and the actions of these managers were seen as amounting to an indirect expropriation. So still in 2022, the work of the IUSCT is being relied upon in ISDS. This is remarkable, since despite the tribunal's full commitment in the last 20 years or so to state-to-state cases, what we call in tribunal jargon succinctly as the private claims production line, was shut down in 2001 with the last private case being decided. But these decisions and awards are still being relied upon in ISDS. So what we are talking about today is of very much relevance and practicality. Now, as I said, my specific topic today is jurisdiction. I'm going to juxtapose the jurisdictional provisions of IUSCT with the jurisdictional framework of ISDS, and to see through that lens to what extent the jurisprudence of IUSCT may be referred to in ISDS. I will specifically talk about 4 topics. Firstly, I will talk about the overall jurisdictional framework. Secondly, I will address the nature of a state consent to arbitration. Thirdly, I will touch upon factual subject matter of the disputes. And fourthly, and finally, I will talk about the legal basis of the allowable claims. Firstly, the overall jurisdictional framework. If you look at the CSD, it really resembles a set of provisions in an investment treaty on state-to-state and investor-state arbitrations. They are very similar. And I should say that when the CSD, the Claim Settlement Declaration, one of the 2 instruments that Heather referred to, was agreed in 1981, it was a groundbreaking achievement for individuals because they were able to directly file cases against a state before an arbitration tribunal under international claim. This was years before any investor relied upon an investor-state dispute settlement clause in the BIT to file a claim against the state, and decades before any estate relied upon the state-to-state arbitration clause in the BIT to lodge a dispute against the other contracting party. That being said, there are, however, 2 main differences between the CSD, the Claim Settlement Declaration, and the set of provisions regarding dispute settlement in an investment treaty. And these differences are consequential for the purposes I'm going to talk about. The dispute settlement provisions in an investment treaty are usually supplemented by other clauses scattered in the body of the treaty, in particular, the definitions clause and the scope of application clauses. The CSD, however, does not avail itself of such a luxury. It's more self-contained and it's self-regulated more and more. So the tribunal was somehow, at least from the subject matter part of the analysis, was free from certain textual entanglements. So it had more latitude to design its own jurisdiction, especially in the first 10 years of its life, when before certain formative decisions were rendered by the tribunal. This has to be taken into account. Secondly, and maybe more importantly, the CSD provides for a procedural protection framework. It reminds you of exceed somehow. It's just procedural protection. But the investment treaties are constituted of 2 parts, the procedural protection part and the substantive protection part. The IUSCT does not have the latter. It's just a procedural framework because the measures that were at stake had already been taken, and the claims were outstanding. There was no reason for the parties to go and reverse engineer the law that should have been applied in the period prior to the Algiers Accords. So in this sense too, the tribunal had more latitude and could be more creative when deciding the claims put forward before it. This is another factor that has to be borne in mind when referring to the precedents of IUSCT in ISDS. And in this light, the characterization put forward by a very dear commentator as characterizing the CSD as a retrospective BIT, although it is very novel and catchy, does not appeal to me greatly, because the CSD did not have actually the substantive protection package that you find in investment treaties. Now I turn to the second part of my presentation, the nature of consent. Investor state tribunals only have jurisdiction with regard to new claims arising after the entry into force of the treaty. So the state consent is in principle prospective and forward-looking. This is in contrast to the IUSCT, which was dealing with outstanding claims outstanding on 19th January 1981. So it was basically a tribunal dealing with disputes arising out of a revolution on an international plane and bilateral framework. So the state consent here, unlike the investor state arbitration, was retrospective and backwards looking. This is also very important when assessing whether a case of the tribunal could be relied upon ISDS, because the parties that filed cases in the courts of Iran and the United States in the period prior to the 19th January 1981, and the actions that the states themselves had taken could be the proper source of information for the states when negotiating the Algiers Accord. So they already, the parties, Iran and the United States, already had a clear idea, at least of significant cases that would be filed before the tribunal. As a result of this, they just brought in some very vague and broad concepts, such as expropriations, other measures affecting property rights, debts, and contracts, to be able to squeeze in as many claims as they could before the tribunal. So all these classes of disputes could be brought before the tribunal. This also made the work of the tribunal more generalized in comparison to investor state cases. Now, I'm driving towards the end of my presentation with the third and the fourth subject, subject matter jurisdiction of the IUS. Article 2, paragraph 1 of the CST extends the tribunal's jurisdiction to claims arising out of debts, contracts, expropriations, and other measures affecting property rights. So the third topic I was going to talk about was the factual subject matter of the disputes. There is very little doubt or controversy that the linchpin of investment treaty law is investment. Of course, there are very different and sharp differences of view, sharp differences of view regarding what investment is, the objective definition of investment, the subjective definition of investment. There are lots of divergences here, but the point, the bottom line is that investment is the concept with which this body of law deals. This is unlike the practice and the jurisdiction of the Iran-U.S. Claims Tribunal. As the cases filed before the tribunal and accepted by the tribunal show, the tribunal dealt not only with investment law disputes, but also with commercial law disputes, property law disputes, and simple civil law cases. So the jurisdiction of the tribunal is much broader, subject matter-wise, than investor-state arbitration. And this is very important because, for example, if you want to rely on an expropriation case in an investment context, this could be apt in principle. But if you're relying on an expropriation case in a non-commercial civil law claim, that could be distinguished simply on factual setting issues. This is another factor that you should take into consideration when referring to the works of the IUSCT. Finally, the legal basis of the claim. It's very clear that investment treaty arbitrations have jurisdiction with regard to treaty claims, violations of substantive standards of protection. In contrast, the IUSCT does not have jurisdiction with regard to treaty claims because, as I said, there are no substantive contents to the IUSCT. The substantive standards of treatment were not defined in the CST. So the tribunal does not have jurisdiction with regard to treaty claims. I'm sure this statement will elicit some questions, and I'll be happy to address them. But turning to contract claims, the situation is the other way around. The IUSCT has expressed jurisdiction with regard to contract claims, as stipulated in Article 2, paragraph 1 of the CST. But investor-state arbitrations don't, in principle, have jurisdiction with regard to contract claims, unless the dispute settlement clause is broad enough to include such disputes, or there is a clear umbrella clause that provides jurisdiction to that effect. Thirdly, investor-state arbitrations don't have jurisdiction to resolve claims based on customary international law. Well, there could be exceptions if the investor-state dispute settlement clause provides for such an eventuality, but in principle, this is not the case in the majority of treaties. This is in contrast again to the IUSCT, because the tribunal has jurisdiction to decide expropriation cases and also international delicts like wrongful expulsion, as have been wrapped up under the general rubric of other measures affecting property rights set out by Article 2, Paragraph 1 of the CSD. This is also very important, because if you're deciding a case based on an expropriation case, based on customary international law rules and principles, then it would be difficult to import that decision to a situation where the investor-state arbitration would be deciding an expropriation case, where the treaty is providing yardsticks for the lawful expropriation, for the standards of indirect expropriation, and for the formula and also the standards of compensation. So this also has to be borne in mind when referring to the work of the IUSCT. So in conclusion, I would say proper reliance on the work of the IUSCT in ISDS requires sifting through the tribunal jurisdiction to find the right match, both legally and factually, to be well suited in investor-state arbitration. In my opinion, a careful analysis of the work of the tribunal, there are certain investment cases that could be relied upon in investment treaty arbitrations, in particular on the matter of indirect expropriation. But let me immediately add a caveat here. The conclusion I just made was within the four corners of a jurisdictional analysis. Whether that also holds true as a substantive proposition has to be considered from the merits angle of the issue. And since this is the province of one of the dear panelists who will speak after me, I will refrain from treading that territory. That's about it. Now I should pass the baton to other panelists, and thank you a lot for your attention.
Thank you very much, Reza, and that was excellent on time. And it gives us a little bit of food for thought for one of the later presentations that will come. I'm not going to name any names, but before we get there, we will hear first from Damien on the issues of nationality. So Damien, you have the floor.
Thank you. Thanks a lot. I will also share some slides if I can. Here should be here. Much more minimalist than Reza, but that's because I'm lazy when I do slides. Just some text and a white background, looks like a lesson. Hi everyone. As mentioned, I'm Damien Charlton. I wrote a paper about the data analysis of the Iran-U.S. claims tribunal, in particular with the avowed objective to show that there is plenty to be learned from the tribunal and its approach on a variety of subjects. And in particular, one of the subjects was with respect to nationality and to claims by dual nationals against one of their own state. Something that we might take for granted nowadays, but actually was not when the tribunal looked into this for the first time at the time. But so to give you a bit of context of what happened, we'll talk today a lot about the decision 3218 FT, which was an interlocutory decision in the text of case A18, which was exactly about can dual U.S. Iran nationals, of which there were quite a few amongst the claimant, can they claim against one of their home state? And in fact, in practice, that was mostly can dual national claim against Iran, because there was no claim by U.S. national against the U.S. But for the context of that particular question, it was not a given at all. Not on the slide, but in the 20s, Borchardt, which was one of the main writers, the publicist of the various nations, was writing that obviously nationals cannot claim against their own states because that's not the point of international law, and especially in the context of diplomatic protection, and that would include the dual nationals, which was maybe not something that is that common at the time. And then you go to the Hague Convention of 1930, which was a convention about nationality, which was very important for two reasons. One of which was to say that under international law, it's for each state to decide who are their nationals, and all the states then have to decide how to deal with it. And especially Article 4, which was kind of ruling out claim against state by their own nationals. But the Hague Convention was not widely ratified, and events then took over in terms of international law in the 1940s and 50s, as you all know. Then in the 1950s, the ICJ was called upon to rule not about the dual nationality claim, but about a case that was all about nationality, notably. Quite a sui generis case in a lot of ways, and we won't go into this. But the important thing here is that it's maybe one of the first time when the courts, the apex court of international law, looked into the idea of when you have several nationality, which was the real and effective nationality for the purpose of your claim. And eventually the decision, the notable, was cited nearly 20 times. I counted in the Iran-U.S. claim tribunal jurisprudence, so it's clearly influential. And then around the same time, you have the Italy-U.S. Conciliation Commission that started to render a number of awards where they applied that effective nationality test to claims of diplomatic protection by dual nationals. And they did it in the context of a very fact-based inquiry. The Mercier-Flegenheimer case in particular, 52 citations in the Iran-U.S. claim tribunal. And finally, before decision 32, you had Chamber 2 ruled on a dual national claims in Esfahan versus Bank Tijaret claims, in which they applied this concept of what is a real and effective nationality for the purpose of the claim. But given that it was only a judgment by one of the chambers of the tribunal, the Iran asked the full tribunal to rule on the issue of whether nationals could, in fact, claim, which leads us to decision 32. And decision 32, well, it would take you less time to read than to the decision and listen to me here, because it's very short. It's very short, it's concise, it's very clear to the point, and it's quite interesting, actually. The bulk of it is answering a debate about whether the claims tribunal is a forum where diplomatic protection is what's governing what's going on. And they say no, actually, it's very different. And then they point to precedents or legal literature to assert that the dominant and effective nationality test was the international law in this respect. And it's quite remarkable because at the same time, and still today, the International Court of Justice has never cited any piece of literature, of legal literature, never. And precedents, the ICJ love to cite their own precedents, but all the precedents, they are not that happy about it. And in fact, in Notable and later in Barcelona Attraction, the court was very dismissive of arbitrations and claims commissions, saying, well, they are all special and in the context of their own treaties and stuff, so we can't give them any weight. So the majority of the tribunal in decision 32 decided to adopt a dominant and effective nationality test, but added, and that will be important later, a very important caveat that nationality might be important for the merits. This decision was accompanied with big dissenting opinions by the Iranian arbitrators, and it was so contentious that most claims on dual nationals were actually the decision from 1984, and most claims were on the merits were deferred for 10 years later when they were decided following this idea of looking to the dominant and effective nationality. And then, so surprisingly, it took quite a long time for this issue to come to the fore in investment arbitration. It's not that surprising, in fact, because early claims, nearly half of the claims in investment arbitration took place under the Exit Convention, which explicitly bar dual national claims. Even though you had a few mentions to the Iran-U.S. Claims Tribunal jurisprudence in early exit claims, but it were about dual nationals of other nationalities than the respondent, and the tribunal say, well, it's irrelevant. And then the first case actually to uphold jurisdiction over dual nationals against its own state was in Serafin versus Venezuela. And in that case, the tribunal's jurisprudence had been cited, but the Serafin tribunal, institutional tribunal, did not rely on it in its reasoning. Where you see a very shift is in Byzantine versus Dominican Republic, where the majority states that although the treaty was lex specialis and you could not follow customary international law represented by the jurisprudence of the Iran-U.S. Claims Tribunal, still they kind of adopted the approach. And the split between the majority and the opinion is to what extent customary international law should have been followed. So no doubt here that the dominant and effective nationality test is what you should do. I should say that before Valentine, actually, the tribunal in Baghdad versus Egypt had already adopted entirely the approach of the Iran-U.S. Claims Tribunal by majority. But at that time, when Valentine was adopted, the award in Baghdad was not available. And the claimant in Valentine had tried to cite an article by Global Arbitration Review about these awards, these unpublished awards in Baghdad versus Egypt, and the Valentine tribunal say, well, it's just a press article, it can't serve as an authority. If only they had cited a reporter, probably they would have won, but I'm just very biased there. And then following Valentine, you had jurisprudence that followed in all the cases in Gelsis versus Colombia very recently, and most recently in January, Trapute versus Venezuela, where the tribunal says that, of course, the U.S. Claims Tribunal was of utmost relevance to ISDS because they are very similar, according to the tribunal, they are very similar form of dispute settlement. Other cases kind of touch on the jurisprudence to say that dual nationals were barred from claiming in investment arbitration, but on another reasoning. And very recently, in August 2022, the tribunal in Soleimani versus Kosovo, which was deciding under a foreign domestic investment law, said that customary international law was not applicable in this context. And finally, I have to say in the 10 seconds that I still have that the tribunals also had some relevance in other issues very related, such as proof. How do you prove that you're national? Your nationality is dominant or defective? Which one is it? The time span. Do you focus on the entire life of the individual, as the tribunal used to say, or do you focus on the investments, which was a split in Valentine versus Dominican Republic? And finally, that's what I find the most fascinating, is that the caveat of the Iran-U.S. Claims Tribunal have actually never been applied or to my knowledge, even mentioned in ISDS so far. Mostly because most cases on dual nationals so far have found that the dominant nationality was that of the respondent state. So we were still to see many cases of dual nationals on the merits, and see if one respondent will try to come about with the caveat and say, hey, actually, nationality should be relevant on the basis of the jurisprudence. That's all for me.
Wonderful. Thank you very much, Charlotte. Charlotte, your name is in bold. Sorry, Damien.
That's fine.
So thank you very much for a very interesting presentation. And I will give the floor on to Aniruddha.
Thank you, Heather. I must also take this opportunity to thank Professor Jan Led and Dr. Jose Antonio Rivas for this very kind invitation and strategy for all the hard work in organizing this panel. My task today in the next 10 minutes is try to explore the relevance of the jurisprudence of Iran-U.S. Claims Tribunal in relation to expropriation, which would within itself also include indirect expropriation in the jurisprudence of investment treaty arbitrations, and also generally in the context of general international law. As a good international lawyer, the starting point for any interpretation ought to be the treaty, which is going to form the basis of the dispute. So if we are trying to understand the precise nature and scope of the determinations made by the Iran-U.S. Claims Tribunal in the context of indirect expropriation and expropriation generally, the starting point ought to be the text which form the basis of the decisions taken by the Iran-U.S. Claims Tribunal. And the starting point, therefore, would be what was Article 2 of the Claims Settlement Declaration, about which Reza elaborately spoke about. Article 2 of the Claims Settlement Declaration provided a rather broad clause in order to test the actions of one of the states. Although technically often it would be in the jurisprudence of the Iran-U.S. Claims Tribunal only one state, although it was meant to be one of the states. So the standard which Article 2 proposed was it had other standards, but the one which is pertinent from the perspective of expropriation is of expropriation and other measures affecting property rights. Now, here is the catch. What the standard provides in Article 2 of the Claims Settlement Declaration is expropriation on the one hand, and other measures affecting property rights on the other hand. Now, these two terms fall on two ends of the spectrum of expropriatory actions, or rather just the actions or measures which a state might undertake. An expropriation by itself is where a state takes the property, that is, the property has been transferred to the state or to any of its instrumentalities. That would be a classical case of expropriation or nationalization. On the other hand, any other measure affecting property is broad enough whereby any measure which is going to affect the interests of the investor, any measure which is going to affect the property, might create rights. That is what was conceptualized by Article 2 of the Iran-U.S. Claims Tribunal. There are very few analogies of this kind of clauses that we find. There are some investment treaties entered into by France, which contains any other measures affecting property rights, meaning it doesn't matter what was the nature of the measure. As long as loss was suffered, the host state was responsible to compensate for that loss. And what comes to mind in particular is the France-Mexico bilateral investment treaty. So you have this other side where the nature of the measure is mostly irrelevant, inconsequential rather. But what lies in between is the standard of indirect expropriation. If I may say, it is really the black hole. And it is that black hole. A black hole is normally something that exists in the space which is black, and it sucks up everything, and we don't know where the things came from and where have they ultimately gone. Indirect expropriation seems to be in the jurisprudence of investment tribunals some kind of this black hole. Now, the Iran-U.S. Claims Tribunal was never deciding indirect expropriation cases, because it was either deciding expropriation cases or it was applying an extremely broad standard, which meant any other interference with property rights, which is by itself quite a broad standard. Indirect expropriation juridically is something in between, and that's what most investment treaties provide. But what we do see in the jurisprudence of investment treaty, not so much anymore, but in the past, as one might say during the early heydays of investment arbitration, when investment arbitration was new and every effort was made to expand the treatment standards, investment treaties as much as one can, the jurisprudence of Iran-U.S. Claims Tribunal turned out to be quite helpful and handy. Now, how did it turn out to be helpful and handy? That's something needs to be explored as well. Reza pointed out to the decision in Starrett Housing, which is of course one of the most cited examples of or definitions of indirect expropriation. Just to remind the audience again that the Iran-U.S. Claims Tribunal wasn't deciding indirect expropriation cases as under, say, a bilateral investment treaty. So what the started housing the tribunal held was, even if the title of the property remains with the person involved or the investor, if the value of the property is lost, then that amounts to an expropriation. Now, started housing is not the starting point of this jurisprudence. The real starting point is IIT versus Iran, where for the first time, this possibility of indirect expropriation without using the word indirect expropriation was expressed. Interestingly, it wasn't expressed in a judicial decision. It was expressed in a separate opinion, in a settled matter. So the parties had come to a settlement, the matter was closed, but one of the arbitrators said, I still want to write a separate opinion. It's pretty much like you prepare for an exam and the exam is cancelled, but you still insist that I want to write the exam. And that too when you don't know what the question paper was, but you still decide to write whatever you know. And it's very helpful to know the Permanent Court of International Arbitration, international lawyers, they say, used to be more wise in the past, but they nevertheless tried to guide them. And one of the guidance to the judges of the Permanent Court of International Justice was that you can write a dissent against a dispositive, against a decision of the court. What we find here is there's no decision because parties have simply entered into a settlement, but one arbitrator nevertheless decides to write probably a nice American law journal article, which ends up as a dissenting opinion, or separate opinion rather, trying to alter the course of the jurisprudence. And what we find is that the same case is being cited thereafter multiple times, and it made its way through to the jurisprudence of the investment tribunals. Now, when it made it to the jurisprudence of investment tribunals, we do come across some shocking things which came across. One of which was in Techmed versus Mexico, the tribunal announced that the jurisprudence of Iran-U.S. claims tribunal is customary international law. Now, an elementary point when asked if something is customary international law, show me opinio juris sive necessitatis. Where is the opinio juris and the state practice to prove there is a custom? But since courts and tribunals are the adjudicators, they can very well say once we declare something to be a custom, it is a custom. I'm reminded of the instance when I was studying my law. One of the teachers told me, it's British Parliament is sovereign. It can do everything except converting a man into a woman and a woman into a man. Probably now it can even do so. So we do see that kind of an instance where suddenly this entire jurisprudence gets picked up and gets announced as customary international law. So there are serious problems with any such announcement. The other problem is it is not just the standard that was applied. It was also the substantive law which was applied. Article 5 of the same claim settlement declaration provides for choice of law. And all it starts, in fact, it starts by saying respect for the law. Cases are to be decided by respect of the law. Choice of law clauses. Of course, it has a reference to international law, but then it also makes a reference to trade and other commercial practice. Several decisions of the Iran-U.S. Claims Tribunal have from time to time pointed out that they have applied lex mercantoria rather than public international law as such. So the questions about what are the elements of public international law in this jurisprudence. In fact, in most of these cases where indirect expropriation has been discussed, there has been some reference to scholarly discussion. All those scholarly writings tend to be interestingly about the American jurisprudence under the domestic constitutional law and not under public international law. So that's the strange and a doubtful origin and genesis of the way in which the indirect expropriation description has been used from where it was not supposed to have existed. But where do we stand now? In the investment arbitration jurisprudence, as I said, during the early days when the party was on and efforts were being made to expand the treatment standards, this was seen as an effort to expand the standard of expropriation, and what came into currency was the sole effects doctrine. According to the sole effects doctrine, it didn't matter why a state has undertaken a regulation. If a loss is suffered, you have to pay compensation. This sole effects doctrine was one of the major reasons of criticism from states. And what we do see a backlash against several other things, and one of the major things being the sole effects doctrine. What we now see in jurisprudence is a realignment in investment treaty arbitration. The tribunals have said sole effects doctrine is not the only test. It is one of the tests, and it is a part of a broader gamut of tests that we would apply. The other tests we would apply is nature of the measure. We will look at the measure and see if the measure is a legitimate public interest bona fide non-discriminatory measure. If it is a legitimate public interest measure, then we would probably uphold such a measure, and irrespective of the consequences of the measure on the foreign investor. Investment tribunals also introduced the neutralization test, that is, the investment ought to be completely effaced. Because if we look at Starrett and IIT, which form the core of this jurisprudence, they tend to say it's only the fundamental elements of the property that ought to be lost. But then the question is, what do fundamental elements mean? Is it complete destruction, partial destruction, destruction of core elements, destruction of ancillary elements? What is core? What is ancillary? So it threw up a lot of questions. But what we do see is a realignment of the jurisprudence in investment tribunals. And that realignment is an effort where investment tribunals are now trying to keep themselves a little bit away from the effect of Iran-U.S. claims tribunal on the interpretation of indirect expropriation. What they do, however, is they use the definition, which is a very nice description. But apart from that nice description as to what indirect expropriation is, we do see that the tribunals have clearly departed from the sole effects doctrine and have moved towards the nature of the measure, and then use sole effects doctrine as only one of the instances. I think it is probably an interesting shift in the jurisprudence. And often it so happens that when tribunals try to unnecessarily expand the scope of treatment standards, then they are to be often forced to take a more reasonable approach. And I think it's really about finding a balance. It's not about either being in the too much in the direction of just protecting investments all the time or protecting regulations all the time. There's a need of a balance. That's what bilateral investment treaty were aimed at. And I do think this shift of distancing from the Iran-U.S. claims tribunal and realignment is a healthy move in the jurisprudence of investment tribunal, which also shows that the investment tribunal has matured and developed. Thank you very much.
Thank you very much. It was an excellent presentation, and it's interesting to hear from Damien about how the picture is maybe a bit more mixed about whether tribunals are distancing themselves from the tribunal's jurisprudence, and then in expropriation maybe the trend is a bit more clear. So that's an interesting counterpoint. So our next presenter is Kabir Dougal, and his slides are up on the screen, so he's ready to go.
Awesome, thank you. Let me just start off by saying any conference that's called wow, just wow, that's awesome. And I'm very grateful to my buddies, Ian, Jose Antonio, Heather, thank you for the invitation. A really timely and fun topic, so I'm delighted to be here. And to my fellow panelists, it's always tough going last. I always joke I'm kept last for reasons of beauty, but that's only to make me feel good about my life. I'm going to be talking about the impact of the Iran-U.S. claims tribunal when it comes to damages. This is the topic that makes my head hurt. And so I thought, why not talk about it, right? Sucker for punishment. But it is a very complicated and unsettled area, I would actually say, in international law at large. So I think it's worth exploring and seeing how the USCT really has influenced our thinking in this area. Now, Anirudh, my buddy Anirudh just mentioned we should always start off with the treaty, and I think that is a good place to start. In the past, in honor of Heather and Ian, I would put up the Canadian model treaty, but they changed it a year ago, and they say the same thing in many more words, and that annoyed me. So we will now look at America. We're going to look at the American model bit, and just to get an example of what a representative treaty tells us on damages, the answer is very little. You're likely going to find any indication of damages only, and to quote Taylor Swift, you will never ever find anything except in the expropriation clause, where we are told in the example you see in front of you, Article 6.1, you cannot expropriate unless, which is amazing to use double negatives to say a positive, but why not? You meet these conditions: public purpose, non-discrimination, due process of law, and then they tell us you got to pay compensation. The relevant article for us from a damages perspective is 6.2, where we are told that the damages shall be fair market value. We're now linking the notion of compensation to a term in economics, to a financial term. And we're given an indication of when do you value the investment. We're said it's the date before the expropriation took place. Now let's just hone in for a moment. The only standard we find is for expropriation. We're told for expropriation, the compensation must be an economic model, the fair market value, right, which economists will tell you is understood as a willing buyer and willing seller. And we are told that the valuation date must be the date before the expropriation took place. Now, this leads to the meta question: what do you do for non-expropriation standards? And as our jurisprudence has interestingly developed, what if you don't meet the conditions given in 6.1, right? So while you can expropriate, we are now told if you meet the conditions, your expropriation becomes lawful. If you don't meet one or more of the conditions, the expropriation is unlawful. And for an unlawful expropriation, do we apply the same fair market value compensation? Fun fact, nobody agrees on this. The Iran-U.S. now tells us something, and we will see, and we leave that as a meta question for folks to think about whether or not you agree with that. But this is what treaty tells us, and again, to follow my friend Anirudh's suggestion, right? The other big source becomes custom. Let's look at what custom tells us when it comes to compensation/damages. And we're going to look at the most mispronounced case in international law, what most English speakers will call as the Chorzo or Chorzao factory case, which makes every international law lawyer squirm because the appropriate pronunciation is the Horsu factory case, a Polish case. Sorry, forgive me, I reword that. A case, the factory named in Polish. And so, as we like to pronounce things the way they more or less should be pronounced in the native, the Horsu factory case, right? This is a permanent court of international justice case. So we're really getting back in time. It's a case people don't know a lot about, so it's just worth talking about. This after World War I, right? This is the shitty period between World War I and right before World War II. So really nasty things happening. But one of the lesser treaties that is going to be signed in Geneva, so obviously we're going to call it the Geneva Convention, but not the famous Treaty of War Geneva Conventions, just a convention signed in Geneva, takes this province from Germany and gives it to Poland, right? Europeans doing what Europeans love, changing maps of countries. So the German flag down, Polish flag out, all the Germans lived there. And it was after a war, and so Germany was a little concerned that the people there may not be treated with warm, fuzzy feelings within their new country. And so the treaty, again, to quote Taylor Swift, tells us something which we probably wouldn't say today, that Poland, you can never, ever, ever nationalize German property. Right? This was to protect the nationals that live there. And obviously, since it lands up in a court, Poland does take over the assets of the Germans living there, this factory. And the question, therefore, is, if a treaty tells you you cannot do something, and you do what the treaty tells you you can't, what is the standard? And the Permanent Court of International Justice tells us the standard is reparation. Now, I just contrast this. The treaty told us the standard is fair market value. Customary international law is telling you that the standard is reparation. Reparation is illegal, not an economic concept. The legal concept tells you wipe out the unlawful act as if it never happened, right? That's what we are told. So we see what a treaty tells you, we see what custom tells you, and we see how, from a damages perspective, you have two different notions. Reparations can be understood as fair market value. That is possible, but the standard is different. Now, why is this significant? This is significant because the Iran-U.S. Claims Tribunal enters in. And they tell us in the Phillips Petroleum case, again, a pretty prominent case, they come out telling you that there is a distinction when it comes to lawful and unlawful expropriation. For a lawful expropriation, we apply the treaty standard, fair market value. But for an unlawful expropriation, we are going to apply the customary international law reparation standard. And then they do something interesting. You remember when we looked at the U.S. model bit, we're told that the valuation, if you look at it, is going to be the date before the taking. We're now being, oops, this is big fingers. We're now being told that for an unlawful expropriation, we're going to give an investor a choice to see what valuation date they want to select, right? This is how the Iran-U.S. Claims Tribunal develops a theory to make a distinction between meeting the treaty conditions for a standard and not meeting a treaty condition. And why is this significant? This is significant because you see after 9/11, the Budapest airport getting nationalized and then getting reprivatized and getting reprivatized to Brits. And the airport has now become much more valuable when the reprivatization takes place. The airport is worth $2.6 billion. That's a lot of money. I would take a tenth of that and be happy. Now, the valuation here is critical because if you apply the treaty standard, we're going to be valuing it at the time of taking when the asset was a lot less valuable than if you apply it at a future date because you have the benefit of this much higher value now. And what does this court do? Oh, forgive me, what does this tribunal do? This tribunal draws inspiration, and if you will see this in the third paragraph, on the Phillips Petroleum case to tell us that for an unlawful expropriation, you can draw on the customary international law so the investor can benefit from this increased value in the asset. Now, whether or not you agree on this will depend on how you see the world, and reasonable minds can get into fist fights on how strongly they feel about this. Should we really be moving the standards, or should we apply what the treaty tells us? Or do we really need a difference, right? What is the practical purpose of giving the same damages for somebody who followed the treaty versus somebody who didn't? I leave that as meta questions for you to, on your own basis of how you see the world, come to a conclusion. But we are also told for other treaty standards, and again, we see the same distinction. Some tribunals tell us for FET, MFN, full protection and security, we're going to apply the treaty standard by analogy. Others tell us, no, we are going to apply the customary international law standard. We can thank the Iran-U.S. Claims Tribunal here for vastly making our lives more complicated. Now, it comes from a good place. It comes from a place of trying to figure stuff out. But it's also a great moment to be alive because we don't have a clear answer on what we have to do with some of these things. And states tend to be woefully not thoughtful about these things. And so I leave that with Porky Pig, and I pass the floor back to Heather. Thank you.
Thank you. Thank you very much, Kabir. Interesting food for thought, and I really liked the images in the top right corner of your slides. I wish I were a student in your class. So we are now at the portion of our session today where the audience, you should feel free to lob some questions at the tribunal. Sorry, not at the tribunal, at the panelists. So please feel free to put those into the public chat. I'll get us started with maybe just sort of drawing some threads from everybody's presentations. We heard at the beginning that the tribunal had a lot more latitude. This is what Reza said, that the tribunal had a lot more latitude than your typical ISDS tribunal in terms of its jurisdiction. Damien also mentioned that the tribunal felt a lot more comfortable referring to kind of a broader set of sources in reaching its decision, and maybe that also links to the applicable law clause, perhaps, of the tribunal being quite broad, shall we say. I think the tribunal has characterized it as such. And Annie Ruda also made the point that they were applying a different standard. They were not applying the same standard that many ISDS tribunals are applying. And then Kabir, basically, the tribunal has kept the lawyers busy. Let's say that. There's been a lot more work for the lawyers. So we have all these kind of not sort of soft critiques of the use, and okay, maybe not soft critiques, but critiques of the use of the tribunal's jurisprudence in ISDS. So I think, but I'll lob an open-ended question to the panelists and for whoever wants to address it. But why has it been so influential if there are all these important distinctions? So anybody who wants to have a go.
Well, if I can start by offering some kind of empirical answer, when I wrote my article about data analysis of Iran-U.S. crime tribunal, I looked at a list of the most frequent investment arbitrators nowadays. I reported at a list of those 100 of, I think, arbitrators who have participated in at least 3 investment arbitration cases. And out of that list, there was a good third of arbitrators who had some kind of link with the tribunal early in their career, be it as a counsel, be it as a secretary to one of the arbitrators on the tribunal, or be it as one of the arbitrators of the tribunal. So clearly, in terms sociologically, these still are 2 very overlapping worlds.
I'm glad that Damien took it, because he has data to support it, and I was going to say pretty much the same thing. But Jean D'Aspermont wrote a very interesting book about international law as a belief system, and his whole thesis was based on self-referentialism, trying to refer to yourself. In fact, I think some of the judges of the ICJ also have had to face this criticism of referring to their own opinions all the time. But apart from that fact, I think one of the problems is when the investment arbitration jurisprudence started picking up, when the cases started picking up, there wasn't much material to rely upon. And the tribunals had to make out something of what they often call the broad treaty languages. Now, somebody would say, well, you should have applied the in dubio mitius and should have interpreted it only as what the text means, rather than trying to broaden it beyond what it means. But they had this handy jurisprudence, and some of them were a part of creation of this jurisprudence. So it was, they found it probably more convenient to simply start referring to it, and now we have that jurisprudence as a main source of interpretation of several investment treatment standards.
I just offer a very quick reaction, because again, going last, you have the benefit of saying everybody before me was correct, and they are. But I think there are 2 reasons that may make it particularly significant. Point number 1, temporally, This is the closest that we have to the rise or the spike in the investment jurisprudence. So it does make sense to look at, what is happening closest in time. Some of the players were similar, right? So ideas get cross-fertilized, and there is this temporal reality. And the second thing is investment tribunals, especially in the early days, are beginning with a blank slate. And, while you can make stuff up, I was going to say make shit up, but that's pejorative. But while you can make stuff up, it's always better to anchor it in something. And even though there are significant differences, there are a lot of similarities that should not be ignored, which is why we also draw on the ICJ jurisprudence. The setup there is very different. We draw on the mixed claim commissions. The reality there is also different. But when you see common themes, you can definitely draw inspiration, to put it mildly. Is there cherry picking? Of course, but that is a part of life, right? In a non-presidential, in terms of jurisprudence precedence system, there will inevitably be some amount of, I like this reasoning, I don't like this, so I'll focus on this and ignore this. But you are still trying to create a legal regime anchored in something.
In approving what has already been said, I should just add that there is no secret that, especially in the formative years of investor-state arbitration, we clearly observe the common law practice of referring to previous cases. And here you have the set of cases where a party has the privilege, has the right to directly lodge a claim against the state. And as counsel, coming from a common law background, you're always looking for cases similar, with a similar factual scenario, factual setting. And you find plenty in the work of the IUSCT. So this was a great opportunity, not only for the arbitrators who sat in the tribunal, also in ISDS, but also the council, who was always looking for some jurisprudence in other tribunals. This was a great asset for them. And they brought it to the tribunal, and the tribunal, the investor-state party citation practices also dealt with these cases. And sometimes they were distinguished, sometimes they were relied on.
Those are some very interesting observations, and I might just add one of my own. The tribunal's decisions were not on jus mundi at the time. So that personal knowledge, that personal aspect probably had quite a lot to do with it, as Samia said at the beginning. That's very interesting.
But they were published. They were published by Cambridge University Press. And I mean, you can in some law libraries, you can see the shelf full of volumes of the tribunal, which in the beginning of investment arbitration was a wealth of resource in this respect compared to everything else. Especially commercial awards were not extremely well published or not as well, and etc. So yeah, I'm thinking that definitely makes a difference.
So we have a few questions in the chat. Oh, well, this will be a fun one, and maybe one not for Reza, not for myself. Not that I'm answering questions, but is it possible to predict the lifespan of the IUSCT? So it's been going for more than 40 years. I think it was envisaged to go for a few years. Does anyone want to hazard a guess on how long the tribunal will keep chugging?
I think it would be unfair to address the question to Kabir, Anirudh, or Damien. Well, actually, from the legal point of view, the parties established a tribunal, Iran and the United States, and it is for them to decide when the task of the tribunal should be terminated. So this is the technical answer. But from what we are doing right now, we are dealing with very, very heavy state-to-state cases, many claims inside these cases, many contracts, many transactions. It's very, very complicated. If I continue, I will get upset And I'm reminded of all the tasks that are on my desk now. But as one of the Iranian judges, former Iranian judges, told the Netherlands head of state at a reception, this is the right question to be addressed to the wrong person.
Yeah, I mean, probably revealing no secret here, but based on my conversation with people involved and everything, probably never. It will never. I mean, probably the last remaining cases are so hard and heavy and complicated, so there might be. We don't. It's very hard to know, but there is a chance that never. I don't know. That has been my feeling.
I just wanted to say that if Heather and Reza can't give an answer, then we might have to ask that to an astrologer. And I don't think any one of us is that. So we can't respond to that probably.
I think Judge Brower, when he retired from the tribunal, made an estimate, I think, of something like 70 years. And that was on the basis of the number of outstanding cases and the amount of time he predicted that each would take to be resolved. But obviously, there are many different factors involved in that decision. So something that's coming up in a few of the questions in the chat, and then I will let you do your concluding observations if we still want to go with that exercise. But to what extent do you think that the model of the IUSCT could be replicated or developed for other kinds of interstate disputes? And also perhaps to inform the possibility of this multilateral investment court. So those are it's two separate questions, I guess, interstate disputes and as a new mechanism for something like ISCS.
Let me take a stab at it. On disputes, and I think the suggestion here seems very specific to what is happening right now. There are plans. There's a plan at Columbia University in collaboration with the government of Ukraine to explore possibilities of a mixed claim commission. As a person who is optimistic about life at large, I put a big question mark on that, because you're either going to need both states to agree, as was the case in the Iran-U.S. claims tribunal, and the jury is out on that, or you're going to need the Security Council to authorize that, and there is a veto power by one of the 5 states, and so I put a question mark on that. So that's my thought out there. Can we replicate the model for the MIC? Now, that's a loaded question. When we're talking about the model, what do you mean? The Iran-U.S. claim tribunal came out with a very specific political backdrop. The players were fewer, and so the structure kind of made sense. For MIC, well, there isn't a consensus if there's going to be one MIC or there's going to be many MICs under many FTAs. It seems under the European vision, it's the latter. So we will have now each MIC having its own jurisprudence, but I'll put that aside. But you need consensus across stakeholders. And the query there is, do we have that consensus among those stakeholders to agree on a MIC? And I think that will guide that. If the point is we have a state-to-state mechanism giving rights and it seems to be working reasonably well, yeah, to that extent, we can draw inspiration, we can draw model. There will be political considerations in the MIC that may make it look very different from how the Iran-U.S. claim tribunal came out. This was a woefully rambling answer, but I hope there was some coherence in what I said. In summary, politics, politics, politics.
If I may add a few things, I think there's a legal element to the question or the answer, and there's a political element to the answer. The legal element is that the Iran-U.S. Claims Tribunal wasn't unprecedented. So all the claims tribunal, the Italy-U.S. claims, the Italy-Mexico claims tribunal, U.S.-England claims tribunal, they have existed for ages. It's not a new thing, even in the interwar period for what Prussia had done in terms of the war. So there are several instances of such a tribunal, claims tribunal being created. Conceptually, theoretically, legally, is there an obstacle? No, there could be one created based on some of these precedents. And of course, the Iran-U.S. claims tribunal can be a good model to emulate. And that also takes one to the political side of the question, whether there would be willingness. We don't know what's going to happen, but the way in which things are progressing, it is possible that everybody may want to have a respectful exit. And these claims tribunal often tend to be a good, respectful exit for all the warring parties. And honestly, for both Iran and the United States, it was a respectful exit. And it was so respectful that none of them signed on to the Algiers Accord. It's not a treaty. It's a declaration by Algeria saying that these two countries are going to do something, and they did it. Those who were not even willing to speak to each other did that, because they realized, well, there's a possibility that we both can have judge from our side, one each, and there'll be a third arbiter who would be the arbiter. He will decide the cases, and we will take a certain approach, which is how arbitrations used to work in the past. And that brings me to the next question of the multilateral investment court. I must say I'm a bit not in sync with the lingo. So when I heard the MIC, I was a bit taken aback, but then I got it. So with the MIC, I think, without making a Mickey of it, because I think Europeans are really serious about it, so we shouldn't do that. And they're really pushing hard. So if we do have such a format, I think what comes to my mind is the move from the Permanent Court of Arbitration to the creation of the Permanent Court of International Justice. Just around that time, if we look at the developments which led to 1907, the Hague Conventions, and then which was the PCA and the eventual the Permanent Court of International Justice, one of the concerns of states was international arbitration, according to them, was highly politicized, because there were representatives from each of them on the tribunal, and then an umpire. He was called an umpire who would decide. So it was almost like having an advocate on your side, and then the umpire was supposed to take a decision. Now that was a very unhealthy situation. And then they thought, let's have a court with a definite tenure who are not bound to states. It would be a random collection of people. So to have a certain degree of clarity, consistency. And what we do see today, if you look at the criticism of ISTS, one of the criticism is if you get the right tribunal, you can get the right award. So it's about the orientation of your appointee, of the chair. So there are all these factors, and they want to get rid of all these factors. So if that's the goal, then I doubt if Iran-U.S. Claims Tribunal is going to be a good model for them. I think the good model for them would be something like the International Court of Justice, something like the International Tribunal of the Law of the Sea. But the impression I get is the way in which the qualifications for the potential appointees are being discussed, or would be discussed, or ought to be discussed, it would be more in the kind of the International Criminal Court. I know it's a different creature altogether. But at the International Criminal Court, there are detailed rules about what qualification the judge should possess. So we might have something where there would be more qualifications to have a filter of bias and take care of all these factors.
Would anyone else like to make a comment on this topic? No.
Right.
So we are over the time that we should have finished our informal networking, but I understand from the organizers that there isn't another panel right after ours, so we have a little bit of buffer. I had promised our panelists that they could make some concluding observations. So if anybody would like to do that, to have some sort of deep thoughts about what we talked about today, please go ahead, stick up your hand. Please go ahead. Reza?
Just very briefly, because some of the points that I wanted to make were addressed when the questions were asked. Today, the subject, the topic of this webinar was the influence of IUSCT on public international law and investor-state arbitration, the great bulk of the discussion was skewed towards the latter part, the investor-state arbitration, as less was said on public international law. So I just want to say a few words on that, because now we are working on the state-to-state cases. So I think the practice of the tribunal on state-to-state cases could be relied upon on certain matters in state-to-state arbitrations or in other international adjudicatory forum, like the treaty interpretation of treaties, how the Vienna Convention of the Law of Treaties, Article 31 to 33, has been applied by the tribunal, can be a guideline for other international judicial fora. Also, the issue of burden and standard of proof when a state is involved, both on matters of responsibility, but also matters of responsibility and also compensation. And the compensation, recently tribunal has pronounced itself on matters such as causation, very detailed discussions, litigation, and also approximation of damages. These are the other areas that public international law tribunals can avail themselves of. So Kabir talked about damages and compensation, and he also raised the issue of increase in the value of the property from the time that the breach was committed to the date of the award. And it's interesting that the tribunal in its latest award has pronounced itself on that too. So it was the valuation of certain musical instruments, and exactly the same concept was applied. So the date of the award actually was considered because the value of these musical instruments had increased from the date of the breach to the date of the award. So it would be interesting to refer to the latest tribunal's partial award on that issue. That's it.
Thank you, Reza. Any other volunteers for some concluding observations?
Just very quickly, because I find that when we go into background to the whole discussion, there is this idea of influence of one body of law on another, which is quite fascinating. And I'm glad that we took the time to try to look into this. And but beyond that, there is really the idea of what is influence and what does that serve, and how do you build up a body of law, and etc. And yeah, just to say that it might not be as simple as that, and that could explain why some things are influent, why some are not, and what is exactly behind it. Just to broaden the idea, because that's a fascinating point of legal of the way the law is being crafted that I find is fascinating.
Just a quick point, maybe. There might be a lesson procedurally for us international lawyers when we look at the influence of the use of Iran-U.S. Claims Tribunal in investor-state arbitration. And I say that because I spent a long time being a litigator under domestic law before being an international lawyer. And whenever I spend time with domestic lawyers or private international lawyers, I tend to find that they are sticklers for procedures. That always trying to see, if I'm going to refer a case, does this case really apply here? And I must say, the more and more time I spend in international law, I realized you can be pretty flexible to pick things that you like as long as you sound cool. That's probably the most crudest way of putting it, which is one of the structural flaws of public international law as you compare it to private international law and private international lawyers. I'm reminded of a lecture which was given by Vaughan Lowe about humility in international law, and saying we public international lawyers need to be a little more humble, look around and learn from others, because it just might help our own profession. And to just make a final point, and which I didn't make before, is in Esteban Kodak versus Iran, one of the arbitrators, and I think I should point him because it's on record, Charles Brower, said we weren't really much concerned about legal principles because there was money in the security account, the money was going to be paid, so we didn't have to really bother about a high standard. It was a pretty flexible standard, and we were going by pretty much what, of course he didn't use the words, but what he described could be categorized as ex aequat bono, a simple equity. So one ought to be careful about in which context the decision was delivered. Of course, that doesn't mean the entire jurisprudence is of no use. There are elements which could inspire, but one has to be careful and, as they often say, take it with a pinch of salt. Thank you.
If I can just react very quickly to what Aniruddha said, because shameless attempt to plug in here my doctoral thesis, which was about citations in international law, and had the final idea that international law is whatever you can cite to prove it, and I think that applies to a lot of what we talked about today. That's all for me.
I end by saying I agree with what everybody said.
Concise, like the early decisions of the IUSCT. Well, I think, okay, we're only 10 minutes over time, 15 minutes before where we should have been, but thank you very much to our panelists, to our audience, to the organizers. This was a lot of fun. This was very great. And I think I'll hand the floor to Jose Antonio, who has just popped up on the screen.
Thank you, Heather, and thank you very much in the order that you appear, Reza and Damien and Aniruddha, as well as Kabir. It was a true pleasure to have a discussion, hear your thoughts from initially a baseline as to the the history and the jurisdiction of and how the tribunal was created, to in-depth analysis as you all did with respect to the jurisdiction of the tribunal, with respect to its framework, the differences that Reza explained between from a framework on international law between the tribunal and investor state arbitration tribunals, and they're going into issues of nationality, which of course are not that homogeneous as Damien explained, and in some of those cases I happen to be the Valentine's case, I happen to be counsel, so it's close to home. And then going into the analysis of expropriation, and then ending up in damages. My own little take on the use of the Iran-U.S. claims tribunal as a source of international law is I'm not that surprised that it's cited as a source, because it is indeed a rigorous tribunal on one hand, and even if we try to go to the quintessential Article 38 of the ICJ statute, 38(1)d, it is clearly a subsidiary source of international law. So why not using them with some rigorosity? So I think this is of course part of international law, and hopefully we'll be treating sources and citations and all of the above with much solidity. In any event, we're very thankful for the amazing contribution. I think that this has been in true nature a panel that really touched upon many aspects, including current political consequences and perhaps influence of the Iran-U.S. claims tribunal in current crisis. Who knows whether jurisprudence will be used in current conflicts, and hopefully will. Now we're going to go into the breakout rooms, and actually, let me see. We'll try 2 breakout rooms, and if not, one breakout room for informal discussion, and let it be known that from now on the recording stops, and we can talk about the weather, the colors of the rooms where you are, the graphics, or whatever you want. So thank you very much, and it was a pleasure to have you all.